our next speaker is Hiroshi Fukurai.
My name is Hiroshi Fukurai, and if you look at it, this is the logo for UC Santa Cruz. That's the bottom of the slide. If you go to words, because we have like 2,500 acres of campus, and if you go to the words after the lane, you see a slug which is the size of like 25 centimeters. And it's kind of surprising. And became the mascot of the university. Anyway.
We have rats.
Very similar.
We have rats.
We'll match them up against
Okay. Anyway, I'm very privileged to be here, CUNY, and for the past 2 years I edited and helped co-edit, with the help of Valerie, 3 special issues of journals, and 2 of them are law journals, and one is international law, crime, and justice. And then I have the privilege of going through all the papers actually being submitted for the publications, and I've seen names of the scholars in this Reed, Steve, Margaret, Ted, Edie, and also law and societies, and Neil, and Sherry. I didn't have a chance to say hello, sorry. But many others, and so and also I'm very privileged to see the new scholars who are also initiating their own research in jury. And as for me, I've been studying. I'm originally from Japan. I came here like 30 years ago, and since then I've been studying American juries. But from 1995, I started to see and also participate in the jury grassroots organization in Japan. And successfully, we were able to send one of the key grassroots organizers into the task force that actually had the privilege of drafting the bill for one of the, actually 2 lay participation systems that were being implemented in 2009. So I started to see the more comparative research, and that's one of the ways in which I tried to make some suggestions about possible research that not only American scholars can participate, as well as international scholars can also participate, as Valerie mentioned just a little bit. And so let me start with the system of Japanese lay education system. And despite the fact, as I said, there are 2 systems being introduced in 2009. Japan had a history of lay participation. First, lay participation system was introduced 1928. 1920. And there was a 12 jury, member jury, just like the ones that we have in a petty jury in the United States and Canada. But it was suspended by the military. I hope I didn't waste about 5 minutes. Okay, thank you. So anyway, it was suspended in 1943. And after World War II, Allied forces actually forced Japan to adapt the American-style jury system, but Japanese refused. So, but nonetheless, Prosecution Review Commission, which was kind of modified version of American grand jury, was being adopted in Japan. Now I'll tell you more about it. And the purpose is to weaken the Japanese prosecutors' authority, because the Japanese prosecutors often tortured and interrogated illegally. And, so that was the purpose of the introduction of this PRC, Prosecution Review Commission. And again, 2009, Japanese government decided to introduce sideline system. That's a mixed tribunal system, using the term of Sanya. And also Prosecution Review Commission with a new provision in it. So let me talk about the first of the 2 types of lay participation systems introduced. The sideline system, or sideline settle, which I call the quasi-jury system, composed of 3 professional judges as well as 6 lay judges. They determine outcome of trial, including sentence. And as of March 2012, more than 20,000 Japanese participated. And Japanese government had extensive study on those people who actually participated, and found 96% of those jury participants expressed their experience as being very positive or very good. And in terms of the social class compositions, about 1 out of 10 are either homemakers, that means housewives or house husbands. But unfortunately, there is no statistics on race and ethnicity, despite the fact that Japanese is a multi-ethnic society. As you know, that Okinawa, it's one of the large ethnic groups. Okinawa used to be an independent kingdom until it was annexed in 1879, as well as a large group of Burakumi, about 2 million, some people estimate to 10 million minorities living. In addition to Ainu people, which Japanese government declared Japan is not a monoracial society in 2008 by designating it as indigenous Japanese ethnic group. So this is the second system, prosecution review commission. It's new. And the function is very unique. It reviews the cases that prosecutors failed to indict or failed to prosecute. This is kind of unique. It's a kind of inverted systems of American grand jury system. And the commission composed of 11 citizens, and the term is 6 months. Unlike here in the United States, it's about a year, like in the state of California. And they are chosen randomly, and they have 3 decisions to make. And they have 3 options. First one is no indictment is proper. That means prosecutors did the right job, so no indictment was actually a proper decision for the given case. Second is no indictment is proper. That's prosecution maybe reconsider their decision. Third one is simply saying prosecutors made a mistake. They should have actually indicted the criminal suspect. And the prosecution review commission determined twice, okay, especially the second one, that the indictment is proper for a given case, then that becomes legally binding. And that was actually initiate the forceful prosecution of the previously non-indicted criminal suspects. Unfortunately, the government doesn't do any survey on this particular system, that's why I was very interested in this system. Now, in terms of the research between ignited after the introduction of side-line system, there have been studies on the impact of lay participation on the procuracy, attorney, judiciary, and police, and also research done in crime and criminal justice process, sex crimes, and Japan uses victim participation system, and also how the pre-trial conference procedure, as well as the introduction of discovery. Japan did not have a discovery. Now it has a kind of quasi-discovery procedure being introduced, how that actually affected disposition of criminal case. And also, many scholars are interested in how jurors deliberate dynamics. Some people actually use simulation techniques. Some of you initiated in the United States. And also jury selection, deselection, like Margaret has been doing. And also some scholars are also interested in the societal impact of lay participation. And I in particular was very interested in the adjudication of American and Japanese armed force personnel, especially in the island of Okinawa, because Okinawa, again, was the independent nation until Japan annexed it. And it was colonized by Japan first, then it was reoccupied by the US military force after the 1945, the Battle of Okinawa. And there are about a little less than 250,000 accidents and crimes being committed, and also more than 1,000 people being killed by US personnel. And so, unfortunately, the Okinawans did not have any opportunity to adjudicate the case over the crimes being committed by either Japanese or American military personnel. This lay participation system actually gave the opportunity for Okinawans to actually be in position to make a decision on the crimes committed by their occupiers. And some scholars are interested in the possible application, extending it from the criminal case into a civil and administrative cases. And especially it's very important given that there is going to be a tremendous civil case, civil litigation filed by the Japanese radiation victims in the future. So I think lay participation system is going to be very important in those cases. Now this is the second system, and then the kinds of research being done on the Japanese grand jury. Now think about it. 99.9% of indicted cases by prosecution result in conviction. That means you need a court. Decision by the prosecutors is sufficient. Okay? But if you actually look at it from the criminal suspect's point of view, people that the prosecutions decided not to indict, they're actually being protected for prosecution. Okay? So the abuse of power by the prosecution in Japan rests upon their decision not to prosecute the criminal suspects. That's exactly what this prosecution review commission does. Evaluates the propriety of non-prosecution decisions by the Japanese prosecution. And that review initiates upon the request by the citizens to review the non-indictment decision. And because of the legally binding authority of this Japanese grand jury, there are a group of untouchables now being exposed to the Japanese forceful prosecution. The JRS is one of the largest corporations in Japan. The 3 past presidents are being indicted and are being prosecuted as we speak for the trial derailment accident that killed more than 100 passengers. Ichiro Ozawa, which I dubbed him as the Dick Cheney of the United States, he was actually indicted and forcefully prosecuted. He was acquitted, but prosecution appealed acquitted. That's possible. So he's still being adjudicated. And American military personnel been shielded by the status of forces agreement. But they are now being exposed for the prosecution. And there are a couple of cases that American soldiers being adjudicated and sent to prison. So the PLC is very important in terms of oversight of government and large corporations that their egregious behaviors, and as well as occupying force. Not only American forces, as well as Japanese forces in the case of Okinawa. Now, this is my suggestion for comparative research. And it's often neglected areas in the United States, because I know it, because I see very few scholars actually focus on, not on the petty jury, but grand jury. And now, grand jury exists in the United States at both state and federal level, right? Federal level, we only have criminal federal grand jury. We don't have a civil. And but in the state of California, we have a civil grand jury that exists in every county, like the 19 through 23 grand juries. In the county of Santa Cruz, we have 21 grand juries, and they serve for a year. And what they do is here, oversight of local government. They check malfeasance, misfeasance, or non-feasance against public officers. And they investigate local government, local jails. If there are prisons, they check those facilities. And they also examine citizen complaints. And they issue a report. And one of the cities in Santa Cruz, Pajaro Valley, was accused of misappropriating some funding, and the city officials are fighting against the grand jury report as we speak. And that's the function. And that's exactly what the Prosecution Review Commission does. It reviews the power of the government in terms of their decision to prosecute. And there are 165 commissions all over Japan. So, why don't we look at the socio-political impact of the jury and their power to act as oversight of the government? And why don't we start looking at the decision-making of the civil grand juries, how they actually evaluate the government agencies and their officials. It's applied in the real cases. And what's the deliberative dynamics on very controversial political issues? People's willingness to participate, whether they really want to participate or not. Because it's for a year. It's not just a case like this. Is there public support? And what's the power of annual reporting of their findings? That's what the grand jury does. And is there any deterrent effect against corporate predations or governmental misfeasance and so on? And another research is there's no civil grand jury system outside of California. And why don't we actually look at possible adoptions of civil function of grand jury, say in the state of California, here in New York, because I think last year there was a report done by the investigative reporter that exposing the hundreds of millions of dollars being appropriated for allegedly creating the computerized accounting system that was put out, all scam, right? You remember that? Here in New York. And it was done by investigative journalists. But if you have a civil grand jury here, New York, it's done by the civil grand juries, just like it's done in the state of California. And also, what would be the possibility of having civil, federal grand jury? And there are 94 federal court jurisdictions. So each jurisdiction, why not have the civil function of the grand jury? Because we already have criminal grand jury system. Why not apply that to the civil grand jury? And each jurisdiction will review civil complaints as well as review the action of FBI, whether they're actually doing surveillance of the citizens or whether federal prisons are being run properly and any other federal offices that fall within that federal jurisdiction. So anyway, so that's the kind of suggestion. So that's what I'm trying to head my research into. I'm also doing the petty jury comparisons, but at the same time, grand jury research. That's the areas I think it's been neglected by the jury researchers in the United States, especially its political function. And that's something I try to look at. And again, lay adjudication and petty grand juries, differential functions, utilities, both in Japan and the United States. And there's a possibility for comparative research. And we need to create really civic oversight around our government. We have National Defense Authority Act, and you're a citizen or anywhere in the world can be detained without cause, indefinitely. We have that law, and also the NSA now has 20 trillion pieces of information of all of the emails. That's the whistleblower that exposed a couple of years ago. And people who have smartphones, their content, and also for your locations in the past and present. Now it's part of the governmental data. It's not for the government, to have those kind of information, but nonetheless, we need to have a leash on the government. That's how I actually direct the research.